SJC-11253, Commonwealth versus Derek Long.
Mr. Shaw, good morning. When you're all set, we're ready for you.
Thank you. Good morning, Chief Justice Gantz, and may it please the court. My name is Robert Shaw. I'm privileged to appear this morning on behalf of Derek Long. My intention this morning is to address the cell site evidence issue and the suppression issue, and then if there's any time remaining, comment briefly on the varied standards we have for ineffective assistance of counsel when there's a case like this with a pre-direct appeal motion for a new trial. The first issue concerns trial counsel's failure to use cell site evidence, which we assert would have served to provide direct evidence of what occurred on the night in question and undermine the core of Courtney Ford's testimony. And I think it's useful to center the discussion on the Commonwealth's primary contention, which is that this is mere impeachment evidence, that it's cumulative, and that when we're talking about impeachment, it can't be ineffective assistance of counsel. And I suggest that there are two fundamental problems with that position. The first is that it doesn't really accurately acknowledge the state of the evidence. So I want to review that briefly. We have a case.
I'm sorry to interrupt, but sure. It's not impeachment evidence. It would have been independently admissible. There's no way to call it impeachment evidence. That's the wrong evidentiary box. But that's not what they mean. They mean that the value of it in this particular case would have been to show inconsistencies between the cooperating witness and the cell site location information. So it's clearly not impeachment evidence. There's no way to call it that. But that's the purpose. I think that's perhaps the more precise way for them to say what they mean.
Well, my reading of their brief is slightly different in the sense that they're relying on case law and saying it's mere impeachment. I understand what you're saying. I think that's accurate. I think that evidence, as a practical matter, most often serves more than one master. In other words, it can be something that directly undermines somebody's credibility and contradicts their testimony. And at the same time, it can provide and demonstrate something that occurred on the night in question. And that's something that happens here. The interrogation of Courtney Ford was essentially limited to his mind. What is his motive? What is his character? Something came out of his mouth one day. It's different on a different day. This was actually evidence that derived from the night in question. The cell site evidence actually comes from the night in question. It demonstrates the chronology of events and the things that occurred. And the reason why it's so important is that Courtney Ford is essentially saying what happened during this critical time period after this confrontation down at Franklin Street. And he says, we went from Franklin Street, dropped someone off in Milton, went up to Mattapan, then we went right back to 93 South, and we went back down after getting keys to Quincy again. And what this evidence shows was consistent with what Mr. Long said. The defense was, and Mr. Long told the police the day after, that he was driven up to Boston and he didn't return to Quincy. And this cell site evidence showed exactly that. Now, the second problem, focusing on the Commonwealth's position and what you've addressed here, Justice Lowy, is that this isn't mere impeachment for the reasons that I have indicated. The cell site evidence showed movement. This is a very dense area. You can see the movement of the cell phone, and it goes from Franklin Street to Milton to Mattapan. Then it goes up north into Dorchester, where Courtney Ford began the evening. And then he's coordinated their calls to Maria DeRosa, his girlfriend, and then DeRosa and Ford move in tandem back down to Quincy. And that's when the additional shooting and so forth takes place. So that's what distinguishes this. Again, it's outside of his mind. It's outside of his motive, his character, contrasting what came out of his mouth at one point versus another point. And that's the problem with not using it.
But help me to understand give me what the closing would have been in your mind with regard to this matter had the CSLI came in, that, you know, that Ford said, in fact, that he did this, and in fact, you know from the cell site location information that.
Right, so the examination of Ford, which was no doubt very persistent and very strong, was insulated because there was nothing to demonstrate, no independent evidence to demonstrate that fundamentally what he was saying was false.
Well, he was false in that, well, it was not false in that he returned to Quincy. And
Well, that's true.
And was in Quincy at the time of the shooting.
And there's no, and that's not in dispute. And see, that's why it's so important, because
So the key is that he in fact stopped, as opposed to going from Mattapan and taking 93 to Quincy, he went from Mattapan to Dorchester?
that he went further north, which is consistent with what Mr. Long told the police, that he was driven to Boston and he didn't return. And by the way, the Commonwealth says that he said something different to the police. That I don't believe that's accurate. I think, and just as an aside, with all due respect, the Commonwealth, in its brief, provides very long paragraphs of facts, and then at the end often cites 20 or 30 pages. I think it's very difficult to understand where that is in the record. Mr. Long, the detective testified, said that he was driven up to Boston, and that was part of the defense, that he didn't return. And that's the critical issue. And so not only was this consistent with what he said, but it fundamentally contradicted. It showed something from the night in question, what actually occurred, that what Courtney Ford was saying was false.
But I still don't understand why the fact that he went to Dorchester means that Mr. Long did not return with him to Quincy.
Well, I mean, it doesn't provide absolute proof of that. But what it does do is it flatly contradicts the events in question, the chronology of events, the timing of events, and who Ford was with, because you can see that there are these calls back and forth between Ford and his girlfriend, Maria DeRosa, and then he gets back up to Dorchester where they are together and where the evening started, and then they move in tandem together. That's just very different from the facts that Ford testified to. Now, I would suggest and ask the court to address this issue carefully and look. I think there's a problem that occurs in the case law, which is that oftentimes this court makes a fairly general declaration about impeachment evidence, for example, and then lower court judges and litigants take that general declaration and we get sort of the argument that we have here, which is impeachment evidence can't be ineffective assistance of counsel. I think the intention behind such a statement from the court is that, of course, this court is not going to get into sifting through the examination of an attorney and prioritizing how best to attack credibility. But that's not something that applies here, where we have a single witness that's carrying the government's case entirely on his back. And the evidence that we're talking about isn't cumulative, and it is independent. And I'd ask the court to look closely at the cases that the Commonwealth has cited. All of them involve evidence that was cumulative, or deciding to go a certain direction in a case after there's been investigation and consultation with an expert.
About the prejudice here, I'm mindful of the acquittal of Mr. Brown as I asked this question, but as far as the prejudice goes, at the first location, the defendant, it seems uncontroverted, gets into a fight.
And he never contests that.
With the victim, as far as motive goes. And then you have the situation where his niece, Messie Long, he says, I was there during the shooting. So this is a really difficult fact for you, I think, because the key to impeaching the cooperating witness is to show that your client didn't go back to Quincy. But his words, said he was there when there was a shooting, and then he says to Tanya that he just got in a fight with a co-defendant, into a confrontation in Quincy.
Right. Well, there's no doubt that he was down there initially, and that this confrontation occurred. And what I have to ask Your Honor is to be very careful and to look very closely at Messie Long's testimony, because Messie Long's testimony is very confused, Your Honor. I think that you will conclude that it is extremely confused. She actually thought She said she was piecing it together. She had medical issues. She was medicated. She was essentially legally blind. And what she was saying was she was trying to piece it together. She thought this happened at one location at the Franklin Projects in Dorchester. And of course, she hears, that I was present. Well, he doesn't deny that this initial altercation happened.
But it was present when someone was shot.
Well,
You just can't ignore that the
Well,
testimony is, I was present when someone was
Your Honor,
shot.
I'm not ignoring it. I think that she is connecting presence with someone getting shot and someone having a gun. And he would have known that they went down and that Ford had his gun and Brown had a gun. So I'm asking you to just look at that very closely. In terms of prejudice, I would also emphasize we have deliberations that go on for several days. We have a deadlocked jury. We have a deadlocked jury who actually reports that they don't believe that they can come to a conclusion on this. And, we have this sole witness carrying the government's case, and we have this cell site evidence that goes directly to the sole disputed issue about whether he went back. And so for those reasons, I think that there is prejudice. Now,
Well, what about Attorney Grossberg's reason? I mean, you kind of have to rebut that and say that it was manifestly unreasonable. So what was unreasonable about his decision not to introduce this
well,
evidence?
I think that the problem here, Your Honor, is a lack of adequate consideration. And I'll run through them quickly. And he concedes he did not know about the specifics of the cell site evidence. He never mapped out the cell sites, which would have been necessary to understand how he could respond to Ford's testimony. He didn't acquire all of the phone records. He didn't have Maria DeRosa's cell phone records, so he wouldn't have been able to use those. And he never contacted the expert, and the experts provided an affidavit indicating that he didn't even know Derek Long existed. So once the trial began, he actually didn't have the capability of calling this expert or introducing this evidence. Now, he does say he thought his cross-examination went well.
So this is a failure to investigate
Well,
case?
as I indicate in the brief, I think two prongs. You can look at it in terms of what happened during the course of trial, and you can look at it in terms of what happened prior to trial and not being prepared. But I think it's really, when you don't have adequate consideration, you can't really say that somebody has made an informed decision.
If you could turn to the illegal wiretap issue.
Yes.
What is the standard of review with regard to a finding of attenuation?
I'm sorry?
With regard to the judge's finding that that there was attenuation, what is the standard of review? Is that a factual finding or a legal finding?
I think that it's really a legal finding. I mean, I think that this is a legal issue that this court should be reviewing de novo very clearly. The motion judge here ruled that Ford's testimony was too attenuated, and the critical question there in an attenuation analysis is whether there was exploitation of the initial illegality. And another way of saying that that's a little more simplistic is there a direct causal chain between the illegality and the evidence in question? And I think the direct causal chain here is really rather stunning, and it begins with the reason and motive for the wiretap, which Trooper Moran testified was to identify additional persons and secure a case against them, just like Courtney Ford. Trooper Russell testified to the exact same thing, and I'd point the court to the Lottie case, which is very important and emphasizes that when you have this connection between reason and motive in the illegality, that's a very potent factor in applying the exclusionary rule. And then we have the wiretap, which is exploited. And what is exploitation? It's really the making use of and benefiting from. And what they do is they summon Gibbs, who is one of two people on the wiretap. They actually inform her of the wiretap. They actually provide her a copy of the wiretap at that moment. They then question her before the grand jury. They warn her that she could say things that would be harmful to her. And then they put her before the grand jury to testify. And then we have Trooper Russell, who testifies that testimony was critical evidence in terms of having a case against Courtney Ford.
Yeah, I don't get that.
I'm sorry?
I don't understand, I mean, I know that it certainly strengthened the police's view that Courtney Ford was an accomplice, but it would not be admissible at trial against Courtney Ford.
Well, it was to get an arrest warrant and to arrest him. And I think at that point, they weren't really clear on what would and would not be admissible, because at that point, the wiretap hadn't been deemed illegal.
Doesn't Judge Sanders have to make particular findings about the police investigation? Aren't these factual matters best left for the trial judge in the first instance?
I'm not sure.
On the standard of review, you say it's a purely legal issue, but don't we rely upon the judge to make these initial findings of fact?
Yeah, but I think that a lot of these facts really aren't actually in dispute. I mean, I don't think there really is a dispute that Trooper Russell testifies that he consulted directly with the DA, that they had concluded they did not have a prosecutable case against Courtney Ford. I mean, he testifies to this.
But how isn't it a factual issue, to pick up on Justice Gaziano's point? Ford is saying that he was going to testify. It's months and months later. He's feeling like they're being disloyal to him, and he's getting this incredible deal, and that he was going to testify, period.
Well, Your Honor,
That's not
yeah,
factual?
well, there's a factual aspect to it, but this is very important, because we have Ford come in and testify that the only reason he surrenders is because of this arrest warrant, whereas previously he hadn't given the police the time of day and they didn't have a case against him. What the judge and the Commonwealth is doing is they're looking at the tail end of this direct causal chain, and they're rationalizing Ford's cooperation as if it occurs in a vacuum. And like I say in my brief, that's like me putting somebody in a box, a small box, but then just focusing on their hands and saying, well, because their hands aren't tied, they're not restrained. That just doesn't make sense. And
Well,
look,
if Ford doesn't know about the wiretap, and I guess there was some question about whether he actually knew about it, so what's the connection to the wiretap if
yeah,
he doesn't know anything about
well,
it?
the connection with the wiretap is what was exploited to get Ford. He is the product of the illegality. He was the purpose of the illegality.
But the exploitation would have to be his decision to tell on his co-venturer,
Well, so,
not the arrest.
well, I think that that's an important issue, because in fact, we shouldn't permit the government to engage in an illegality, get somebody arrested and put them in prison, and then because they're in prison, assert that somehow it's independent of the illegality, number one. Number two, Ford absolutely knew about this wiretap. Gibbs testifies in the Fruits hearing that she told him about the wiretap. Gibbs testified that she had told his mother about the wiretap.
But the judge did not find that he knew about it.
Well, she mentions that he seemed unsure, but I think the evidence is rather overwhelming that he knew about it. And again, the point being that once we arrest him, which was the point of the illegality, and he's in prison, which is an inherently coercive circumstance, and he's charged with first-degree murder, he's not out on bail, he's facing life in prison without the possibility of parole. They have complete leverage over him to somehow assert that his decision is somehow independent and voluntary, I think is just fanciful. I just don't think, and I don't think it's good policy.
Well, to prevail, am I correct that you really need to persuade us of two things? One is that, but for the wiretap, he would not have been arrested, that the arrest was the result of the wiretap, and that but for causation is the standard with regard to attenuation.
Well, I think that in terms of an arrest, I mean, the judge says, well, I think he would have been arrested for something. Something is different than first-degree murder. There's a completely different...
All right, so it's but for that he would not have been arrested for first-degree murder. It was the prospect of life without parole that squeezed him to along with other things, that squeezed him to cooperate, and therefore
Yeah, and
there was a taint.
And inevitable discovery, I mean, needs to be certain as a practical matter under the case law, and we certainly don't have that here.
But have we said that but for causation is sufficient with regard to this type of attenuation?
I'm not sure if that language has been used, Your Honor. And just closing up, I think that what really happened here is the judge was really concerned that the case against Brown was not going to survive. That really is a problem in itself because Mr. Long is entitled to have the merits judged relative to him. Then we have the judge who makes a very subjective judgment about the cost to the criminal justice system. She relies on the U.S. Supreme Court. She doesn't rely on the Declaration of Rights, which has been argued at every stage. We have a state statute here. It's a state issue. And, you know, with all due respect to the U.S. Supreme Court, over decades now, that court has really sort of gutted, for lack of a better word, the Fourth Amendment and the exclusionary rule. And this court has very wisely and consciously chosen not to follow that. So given the fact that our Declaration of Rights is more protective, I'd ask the court to base the decision on that.
Okay, Justice Scalia, I'm sorry, there was a question that I interrupted.
I was just going to pick up on Chief Justice Gantz's point. How can it be but for if there's a element here that there's a separation that is so attenuated that it dissipates the taint? Doesn't just the very doctrine say that it's not but for?
You know, I'm somewhat confused by the but-for issue. I'm not sure how. I'm not sure what the concern is there. I mean, I've never heard that language used, and it really what it is did they exploit the illegality to end up with the evidence at issue? That's absolutely clear here. Is there a direct causal chain? It's straight.
Okay, thank you.
Thank you.
Ms. Alford, good morning.
Good morning, Your Honors. Pamela Alford for the Commonwealth. With me is Craig Kowalski. We are asking that both the motion judges' denial in part the motion to suppress and the trial judge's denial of the motion for a new trial be affirmed. Starting with issue 2 at the standard of review. This is whether the taint was dissipated is a question of fact that comes directly from Commonwealth versus Casso, which says whether the decision to testify, and the quote is, was sufficiently an act of free will to purge the primary taint, and I'm paraphrasing now, is a question of fact which we leave to the learning, good sense, fairness, and courage of the trial judges, and that's quoting Nardone versus United States. The judge made very important credibility findings after a full evidentiary hearing. So after this court affirmed the motion judge's allowance of the motion to suppress the wiretap in what we'll call long 1, the same judge, and I think that's very important, then did rounds of pleadings of what the effect was, and then did an evidentiary hearing where Gillian Gibbs testified, where Courtney Ford testified, and where Trooper Jeff Russell, who was case officer, testified. She also took a number of pleadings, a number of exhibits, many put forth by the defense, of what was before the police at the time of Gillian Gibbs' testimony, and those are included into the Commonwealth Supplemental Appendix and Impounded Supplemental Appendix. It includes the affidavit for the arrest warrant for Ford. It includes Trooper Moran's affidavit for the original wiretap warrant. It includes affidavits of the prosecutor of what contact was and was not made with Ford and with Gibbs. It includes Gillian Gibbs' jury testimony, and it includes what actually was gotten from the wiretap, which only, as the motion judge found, peripherally mentioned Ford. And the motion judge also credits Ford's testimony that he did not testify, that he did not decide to cooperate because of the wiretap, that he decided to testify because of what he perceived as threatening conduct and disloyalty and disrespect from Brown and from Long. That is a credited finding after an evidentiary hearing that deserves deference. The standard of review, to answer Justice Gantz's question about is it enough that there's a direct causal chain, the Commonwealth's position is that's a floor, a necessary prerequisite, but not in itself a sufficient condition. And that comes from Commonwealth versus Glavin at 354 Mass 69, a 1968 case. which talks about that evidence doesn't become subject to suppression just because it came to light. It would not have come to light but for the police action. And then the quote is, rather the more apt question in such a case is whether granting establishment of the primary illegality, the evidence to which the instant objection is made has come at the exploitation of that illegality, or instead by means sufficiently distinguishable, be purged of the primary taint. And looking at the three factors this court has set out, temporal proximity, temporal proximity, intervening circumstances, and flagrant misconduct, all three factors support the motion judge's finding that this was sufficiently attenuated. This was 7 months.
Not the third. I mean, the judge found flagrant misconduct with regard to the affidavit.
There are 2 points to be made for that, Your Honor. One, the judge found in Long 1 and referenced afterwards that she found that the trooper had intentionally or recklessly made intentional misstatements. This court on Long 1, in review of the Commonwealth's appeal of that decision, did not find it necessary to reach the judge's credibility findings. Long 1 was a case where the trooper did not attach there were jail recordings that supported probable cause for the wiretap warrant. The trooper did not attach those recordings. The judge found not that what the trooper said was incorrect, or that there were matters not included that were directly contrary to what the trooper said, but that looking at the excerpts in a whole, she put a different interpretation, a more benign interpretation that she found did not amount to probable cause. This court didn't address the issue and instead found, and I suggest what was a clarification of the law, that the facts did not support probable cause of a criminal enterprise. Long 1 has now been cited for that point, so I suggest that this is something new. That the 2 other points may be made. One, the judge recognized this. She said, yes, this is what I found. I still think, given that as a fact, as the judge took it as a fact, she still found that the application of the exclusionary rule was not appropriate here. She looked at what the Commonwealth lost, and I suggest that's entirely appropriate to see if there was looking at a substantial or prejudicial violation, that the wiretap was out. The fact that a witness, Gillian Gibbs, was developed from that wiretap who had statements made by the defendant, that was out after the evidentiary hearing. That she then said the application of the exclusionary rule, that the taint is dissipated by a witness who chose to voluntarily testify 7 months after the wiretap, who was known to police before the wiretap, and who the wiretap only peripherally mentioned, is not clear error. And nor do I suggest it's flagrant misconduct when the police went through the procedures to get a warrant. I disagree that there was any intent, but given the motion judge's findings, they went and got a warrant. They used it. They got another warrant for Courtney Ford. If you look at cases such as Fielding, where they said, okay, the police got a warrant, but there wasn't probable cause. They said, well, the conduct's not the conduct's not flagrant because the police tried to do the right thing. Certainly, I'm not suggesting that the wiretap or the evidence that was a direct effect not be suppressed, but I do suggest it goes to attenuation. And this conduct was sufficiently attenuated. The police had much evidence regarding Courtney Ford, and the fact of the matter is, Courtney Ford's testimony was he didn't want to talk to the police, and after his arrest, that didn't change. It didn't change for 5 months. The judge made a credibility finding, and Courtney Ford had protections. He had counsel at that time. Counsel reached out to the Commonwealth. And if you look at Cecilini and Casso, I suggest the test is really whether this is a voluntary act. Casso in particular diminishes the idea, not diminishes, but does not focus on the idea of flagrancy and says even if there was flagrant misconduct, which that court did fine, we need to look at whether this was a voluntary action.
But I mean, that's, of course it was a voluntary act, but it was a voluntary act made in the context of somebody who was now in jail without bail, awaiting trial for murder in the first degree, and that means that the Commonwealth can squeeze him a lot harder than if he's sitting on the street and they're looking for cooperation, or if they're going to be charging him only as an accomplice, as an accessory after the fact. What do we do with the fact that he was arrested for murder one very shortly after the wiretap was received, and the trooper said that that mattered a great deal in terms of the decision to charge him with murder one?
You look at this court's precedent for both cases where a defendant who is under arrest looks at somebody else's statement that is then suppressed and makes a statement, and this court's precedent when somebody is arrested illegally and then makes a statement. I suggest there are two analogous standards, and here you look at, was there temporal proximity? Did it happen right after or not? Here, Courtney Ford continued to not talk. This is not the case. These are the cases, as the defendant cites, where out-of-state cases where the government finds, say, undocumented immigrants due to an illegal search, and then is prepared to deport them immediately. The leverage there is great, much more. Here, Ford continued not to talk. Ford had counsel. Ford reached out to the Commonwealth. There's no evidence here that the Commonwealth was using that leverage to go after Ford. And most importantly, you had the judge's credibility finding that the wiretap wasn't the reason Ford cooperated, that there was the intervening circumstance.
I grant you that, but the wiretap was the reason why he was in jail charged with murder one.
Well, I suggest there was a lot more to it than
Well, I
the
mean,
wiretap.
and that's, I guess, what I mean, do you, Mr. Shaw says that, and I will look at the law, but I will take your point for now that but for is not the standard. But do you agree with Mr. Shaw that but for, that the evidence is that but for the overheard conversation, he would not have been arrested for murder one?
I do not agree with that, and I think it's important to distinguish looking at the facts in an inevitable discovery lens and in an attenuation lens.
And what would have been found after the wire that would have caused them to arrest him for murder one?
Well, I suggest the investigation would have continued, that there was, so it is true, and if you look at Trooper Russell's testimony, that motion to suppress 59, he's asked, he agrees that Gillian Gibbs is a critical witness. He agrees, and so these are not his words, these are what he's agreeing to, that it put them over the top. And and the question is, you look, even if you have probable cause, whether this would be a prosecutable case, correct? And he agrees, and the next question is, you did that here, and he agrees. Probable cause was something that went all the way back. Commonwealth, to be fair, was concerned that whether it had probable cause, that was something that came out in Long One, one of the reasons that they got the wiretap and instead of just arresting Ford. But you had abundant evidence that Ford was a key target of the investigation. Even Trooper Moran, I believe it's at Supplemental Appendix 42, says there's probable cause to believe that he's at the scene. You have, at the 236 Franklin Street address, the defendants saying see no. You have in two witnesses from the Willard Street address who said that they were two-wayed by Courtney Ford shortly before they heard shots. One of them says that Ford asks her the next day, what's going on in your building? If you look at the Trooper Moran's affidavit to the wiretap, they then do cell site location information that showed that Ford's cell phone was around there. Ford is talking to Richard Long, the defendant's nephew, that you had driven Ford away. So to say that this is not a case such as Latty, where by inducement of the police, the defendant informs them of separate crimes that the police are completely unaware of. This is a case where the investigation is ongoing, that in terms of attenuation, as opposed to inevitable discovery, where it needs to be virtually certain, because the police illegality for inevitable discovery, you have an illegality that directly produces, normally immediately, Nix versus Williams is the main case here, the action, and then you look, would it happened otherwise? Well, here you don't have the direct and immediate action. You have a temporal distinction. So I do think it is appropriate to look at what did the police have in terms of how important was the taint to Courtney Ford's testimony. If you look at Commonwealth versus Estabrook, it's a 2015 case by this court that talks about tainted CSLI information. And this court looked at statements made by the defendants after the police had the CSLI, but before the police confronted them with it. And this court found that statements made before the CSLI was shown to the defendants was not subject to suppression. If I may turn briefly
Yes, please.
to the first issue. The motion for a new trial judge, who's referred to as a trial judge, appropriately denied the motion for a new trial. First of all, this was a strategic decision. Counsel in his affidavit says he was aware that Brown's counsel, Brown had been tried first, had Paul Dobbitts as a witness, that he gained a general understanding of his testimony, that he spoke to Brown's counsel and made the decision that this was not necessary to go into, that he had enough areas of cross-examination. And in looking at counsel's cross-examination, this was 227 pages of cross-examination that went through a myriad number of topics, including independent evidence of the crime. And that is, counsel tried to use the medical examiner's testimony that there were that the victim was shot 3 times. One shot was from the front graze wound to the left chest. One shot was to the back of the leg, and the shot that was determined to do the most damage was entered the back left chest and lodged back left back and lodged in the muscles of the right chest wall. And so counsel did a demonstration, had Ford place certain people of where he claimed that Brown and Long were, and used the medical examiner's testimony that there were 2 shots from the rear, with Ford's testimony that he saw the victim facing front, and then counsel's view, which was disputed by the Commonwealth, didn't see him, never saw him turn around, to say that his view was completely, that he was not credible. So that...
The appellant's argument is not that Mr. Grossberg didn't do a great job on cross-examination. It's that he could have done even a greater job if he had actually gone through the effort of plotting out the cell site location information and taken into account where Ms. DeRosa's cell phone would have been, because that would have been evidence independent of just these inconsistencies that would have demonstrated that some of what Mr. Ford said was inaccurate.
This goes to whether the strategic decision was manifestly unreasonable. The cell phone testimony from Brown's trial is included in the defendant's record. The cell phone testimony can reasonably be described as extremely dry. I think at one point, most of it's marking certain things on a map.
I read Mr. Mitchell's comment about what he thought about the information that he was putting in, but it resulted, or at least contributed to a not guilty.
Very different positions. Brown was not even known until Ford identified him as the second shooter. Indeed, part of the issue in Long One was that the police suspected but was not certain that Ford was the second shooter. And then after Ford cooperated with police, he gave up Brown. There was also substantial motive evidence on the part of Derek Long that he was the one that got into the fight with the victim. And then if you look at that second visit to 236 Franklin Street, that there was, when they went back, not only were things stolen, but Janet Ojo, the defendant's ex-girlfriend, testified that her clothes were destroyed, covered in bleach. Well, that goes to a real motive of the defendant, who the testimony was very upset that he couldn't get his clothes back from Janet Ojo. The cell phone evidence showed maybe a 20 to 25 minute period where the defendant may not have taken the direct route back to Quincy, but then the Ford cell phone going directly to Quincy, where the murder took place. It has nothing to do with the timing of the events. It was clear that there was one visit to 236 Franklin Street, a trip up to Boston, a second visit to 236 Franklin Street, and then at approximately 11:55 shooting of the victim at the Willard Street location in Quincy.
One more question, at least. Judge Fishman seemed to think that the fact that the CSLI would have corroborated Ford's statement that he was in Quincy at the time of the shooting would have supported his testimony. Mr. Shaw says that was not even in dispute. Do you agree with that?
I agree with Judge Fishman, Your Honor, because if you put on the map a visual of Ford's cell phone going after the 20 to 25 minute contested period, going down to Quincy the same way that they went the first time with the defendant admittedly in the car, I do think it provides a strong visual that that's what happened the second time.
All right, thank you.